well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And yet it is, and will continue to be, for at least another term or two from the Supreme Court. Good Monday. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. The breaking news, wrote about it at Bearing Arms. Snope and Ocean State Tactical. Cases dealing with Maryland's ban on so-called assault weapons, Rhode Island's ban on quote-unquote large-capacity magazines. Both denied cert by the Supreme Court today after months and months of being heard in conference. These cases were first heard back in December of 2024. They have been heard almost weekly since then. And today we got the news that we were not wanting to see. Again, both these cases denied. Justice Brett Kavanaugh writing a statement, not necessarily a dissent from the denial, but maybe an explanation as to the denial. And it starts out, honestly, I got to say, based on what Kavanaugh said, I think that he would, A, have voted to hear this case, and B, voted to overturn the Fourth Circuit decision upholding Maryland's ban. This is a portion of what he said in his explainer today. He said, given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. He went on to say, under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15s at issue here from the handguns at issue in Heller. AR-15s are semi-automatic, but so too are most handguns. Semi-automatic handguns and rifles are distinct from automatic firearms such as the M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. In short, Justice Kavanaugh wrote, under this court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with a lower court decision or that the decision is not worthy of review. He went on to say the AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals, including the Third Circuit, the Seventh Circuit, the Ninth Circuit, and he said that he believes, I want to make sure that I get this language correct here. He says that, and we got a separate dissent, from Justice Thomas. I had wondered why Justice Thomas was not signing on to the denial of a certiorari, but it's because he wrote a separate denial. Kavanaugh wrote that additional petitions for certiorari will likely be before this court shortly. And in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. So you've got four justices, I think, that would agree to hear this case. That's all it takes to hear a case, but it takes five to win. And I don't think we've got that fifth justice yet. Mark Smith, Four Boxes Diner on Twitter, said, it's terribly frustrating because we seem to have the votes on the merits to find AR-15s are protected arms, yet SCOTUS refuses to be sufficiently assertive in protecting the right to keep and bear arms. Now, I think that Professor Smith is a very smart guy. I respect his opinion a lot, but I will disagree with him. I don't think that we seem to have the votes on the merits. I think if we seemed to have the votes on the merits, then Snope and maybe Ocean State Tactical would have been taken up by the Supreme Court. Again, you've got a separate denial, a dissent from the denial by Justice Thomas. You've got Justice Gorsuch and Justice Alito indicating that they would have accepted cert. You've got this opinion from Kavanaugh, not an opinion, but a statement from Kavanaugh, certainly suggesting that he would have struck down Maryland's ban. So there's your four. What we didn't hear, who we didn't hear from, Chief Justice John Roberts, Justice Amy Coney Barrett. Either one of which would be the fifth and deciding vote to overturn the Fourth Circuit's decision and declare that these bans on commonly owned firearms that are used for a variety of lawful purposes are in fact unconstitutional. So the easiest explanation for me, and again, this is speculation, but the most logical explanation, I should say, would be that fifth vote is not yet there. Maybe not yet there, which is why Justice Kavanaugh said he expects that the court will take up this issue in the next term or two. That the one of these two justices, keeping an open mind, maybe both of these justices keeping an open mind, but they want to hear more arguments. But we're not there yet. It is incredibly frustrating. And, I tell you, I've talked about this so many times with Mark Walters on Monday morning, host of Armed American Radio. We've had Mondays with Mark. Snope has been a huge topic of conversation. So when I saw the news break, Mark was the first person I reached out to and said, hey, you want to come on and talk about this? In fact, Mark hadn't even heard the news. It was that quick in me talking to Mark. So Mark was gracious enough to get a camera ready and sit down to give us his initial reaction to the Supreme Court's denial of the Maryland gun ban case, the Rhode Island magazine ban case. Take a look and a listen. Well, Mark, I don't know how many times you and I have talked about the Snope case on a Monday morning, waiting, watching to see what the court would do. Today we got our answer. It is not what we wanted, not what we were hoping for, not what we were expecting. A bitter disappointment, I think, to put it mildly. The Supreme Court denying cert to both Snope and Ocean State Tactical. We got this statement from Brett Kavanaugh, basically counseling patience, right? We have every expectation that the court's going to take this up in the next term or two. But that doesn't explain why the court didn't take up this case now. This is a case that had been fully briefed, fully decided on the merits. It had been decided before Bruin. It got GVR'd back down to the Fourth Circuit, got re-litigated. Fourth Circuit once again upheld Maryland's ban. This was ready to go. And yet the Supreme Court turned this case away.
Yeah, you and I just talked about this on my national radio show last night. You and I have talked about this for what now, going on a couple years at least. This case has been linked. And, I've been very optimistic about it. And I up until just now, in fact, I got the call from you is when I found out about this just a little bit ago. But I maintained my optimism on this because, as we talked about before, this case hit everything as you just laid out. It had it all. It had been granted cert. It was vacated and remanded back. The case had been decided on the merits by the entire Fourth Circuit. This doesn't make any sense. But let me say this, and I want your opinion on this because I'm not sure what we're going to see from the left. Reading Kavanaugh's statement in its entirety. Mm-hmm. If I'm the left, I'm not doing a powwow dance around the campfire on this. What Kavanaugh essentially said was, he knows why. You get the sense from reading his statement that he knows why the court didn't take the case. Unfortunately, we're not going to know why. But he did lay out a little bit of groundwork here going forward. And he did get specific that he had no doubt the court was going to make a decision as other courts continued to move this through, and that they would eventually decide this within the next term or two. That's a fairly specific statement. So I would give anything in the world to know what was going on in the minds of the justices as to why this case wasn't taken when it was. Clearly, they're looking for something else, maybe something to strengthen it through another split. I don't know. And we're not going to know the answer. We're going to sit and pontificate about this, Cam, all day long. Trust me, that's what I'm going to be doing on Armed American Radio, likely for the remainder of the week. Mm-hmm. But if I'm not doing a powwow dance around the campfire. Now, you and I are smart enough to know that is exactly what they're going to do. But they shouldn't. They're going to have the media on their side. They're not going to refer to the final statements in Kavanaugh's statement here relative to them taking this case. They're going to be all over the assault weapons ban stands. I think you're going to see a big push from the Democrats in Congress on the back of this.
Yep.
For more gun bans, you're going to see more of it in blue states. And there likely is going to be some, Kavanaugh pointed out there will be cert applications in the future on other cases. But again, I am absolutely frustrated and flustered as to why this one wasn't taken when it checked every single box, brother. I don't know.
Well, listen, let me give you the pessimistic take, right? So we had Justice Gorsuch, Justice Alito, who would grant the cert. We know that Justice Thomas would grant the cert. Sounds like Justice Kavanaugh would have granted the cert, right? He talks about how these are guns that are in common use. And it's certainly, suggestive that he would have taken this case. So that gets you 4. Right. And it only takes 4 to grant cert, but you need 5 to win. So the pessimist in me says that while the 4 votes to grant cert and to hold this ban unconstitutional are there, it's the 5th and deciding vote that is missing right now, right? Either Chief Justice Roberts, Justice Barrett, they're either on the fence or they have indicated that they are not on board with overturning these bans. And
we don't have any history from Barrett here. We do have history from Roberts. Let's be fair to Roberts here briefly.
Mm-hmm.
It's a little wishy-washy. We know that in other areas, but specifically staying on point here, he has voted with us in all 3 major Supreme Court 2A cases.
Yeah, he has.
So I find it very difficult to believe that he would back off of that now. I think that points to Barrett having some questions. But let's be honest here. That's 5 justices without Barrett who might move to the liberal wing of the court.
Right.
That's a victory for us. So what are they concerned with here? Was it both?
I think it has to be both, because of exactly what you just said, right? If they had one of those two, if they knew that one of those two was going to be on board, that would give you the 5. Even if it's a 5-4 decision, not 6-3, like we saw in Bruin. Listen, Heller was 5-4, right? And that's still the law of the land, technically. So, yeah, that tells me that there is some concern about Roberts or Barrett. And maybe, listen, it would not surprise me. And again, this is all speculation. It would not surprise me, though, if Chief Justice Roberts, who, as you say, has been on the right side of this issue in all 3 major cases, if he didn't say, hey, I want to see more arguments. I want to see what these appellate courts do. I'm not opposed to taking this case, and I'm keeping an open mind, but I want to see what happens with, the First Circuit case, with the Third Circuit case, ANJ RPC versus Platkin. Oral arguments are coming up at the end of the month in that case. And maybe that's the case, right? Maybe it is one or both of these justices are still keeping an open mind. They just want to hear more briefings. They want to hear more arguments. The problem from a gun owner's perspective is exactly what you just said. It's going to take at least a term for these cases to be ripe for review, if not 2, as Justice Kavanaugh mentioned. And in the meantime, what happens at the state level? I'm sitting here in Virginia where Abigail Spanberger, the Democrat nominee for governor, is running in lockstep with Moms Demand Action in every town. She is saying, if I get elected, the Democrats keep control of the General Assembly, we're going to have a semi-auto ban, right? We have seen, the sort of, we talked about it last night, the new definition of an assault weapon, right? Any gas-operated semi-automatic centerfire rifle or shotgun that can accept a detachable magazine. That's what they want to ban. Yeah. They've not been successful in doing that, right? The bill in Colorado got watered down. Bill got defeated outright in Hawaii, was left to die in committee in New Mexico. They're still debating it in Rhode Island. I'm very curious to see what the reaction is going to be here in Rhode Island. But this is going to empower and embolden anti-gun activists and anti-gun Democrats, both in blue states and at the federal level. And this is, this is going to have an impact. The denial of this case is going to have a negative impact on our rights, not just for those gun owners living in states where these bans are already in effect, but in these battleground states where, in 25 and 26, if Democrats take control, they are going to push hard to get these bans on the books because, again, that's something that might weigh on the minds of the Supreme Court justices, right? Well, look, we've got 13, 14, 18 states that have banned these guns. Doesn't that matter to some degree or another, right? I'm very concerned about the long-term ramifications of even kicking this can down the road a year or 2.
As you should be, because while there's some things to be positive about in Kavanaugh's writing, what you just pointed out is dead on. And look, if you're living behind the blue wall right now, ladies and gentlemen, you know exactly what we're talking about here. If you're in Massachusetts, if you're in any blue state, they are going to use this. And let's talk about that 2-year deal. Look, it's historical precedent shows us that we may very well lose the House in 2028. Mm-hmm. Okay. Look, this or 2026, this does not bode well for us in the short term. In the long run, it might. And all of us want this now. And that's why we're so frustrated and angry about why this case wasn't taken right now, because it did. It checked every box, as you said. Clearly, the court is looking at other things that we're not looking at. They clearly want to see some other lower court precedent set here before they grapple with this, which Kavanaugh made clear it looks like they're going to do. But during that process, good heavens, they are going to, while they shouldn't be, doing that powwow around the campfire right now, individual states clearly are. Your situation in Virginia highlights that point. They're going to run on this now. They've got a little fuel behind them as a result of this denial. And you know what they're all going to say. It's not just a matter because the case wasn't decided on the merits by the Supreme Court. It was simply denied cert.
Mm-hmm.
There was no decision. And Kavanaugh made that very clear in his writing. We did not decide this, but we will going forward. Well, going forward means what happens after the midterms? What does that mean at the federal level, not just behind the blue wall in the individual blue states? To me, this was a terrible decision not to take this case. But for the reasons that we're discussing here right now, it is pure speculation. It is pure pontificating on our part right now. There are some clues in here that we didn't have as early as last night, Cam, when you and I were talking about this, based on Kavanaugh's statement. I'm curious about some other things too. Why didn't we hear from Thomas on this? Why was it Kavanaugh? Thomas has been very upfront about his position here. Mm-hmm. Maybe that's why Roberts gave Kavanaugh this, because Thomas's writing may have been very scathing to the court, and maybe he didn't want that out there. I don't know. None of us will ever know the answers to those questions.
And it's interesting, too, because, as you say, Justice Alito and Justice Gorsuch would grant the petition for a writ of certiorari. That's what Justice Kavanaugh said. Justice Thomas not mentioned there. Now, Mark, I cannot imagine a world in which Justice Thomas would have denied cert to Snope. So why he was quiet on this, again, is one of those questions. We'll probably never know the answer to that. But, clearly there's a lot of discussion taking place behind closed doors. There is a lot of, I think, political machinations going on. We don't know, again, why it took so long for the court to make this decision, unless there was, again, this is pure speculation, but maybe there was some horse trading on the issue, right? Maybe there was a verbal promise from Justice Roberts or Justice Barrett that, listen, we'll go along with cert, but we just want a little more time to see this issue fleshed out. We want to see that Seventh Circuit case come up, or we want to see this Third Circuit case. Again, we don't know, but something had to have happened for this case to have been held on for as long as it was. Yeah. And then, kick down the road a couple of years. That if this was just if this was going to be a denial from the get-go, mm-hmm. we would have learned that, I think, in February, March. I don't think we would have had to wait until June for that.
No, and you and I, like I said, we've discussed this multiple times. As I said last night on my show, there has been more than ample opportunity for the court to deny cert in this case. Why did what are we at? 18 conferences now? Something ridiculous like that. But you pointed out last night, and now prophetically so, was it Apache, I think, 15?
Yep. Yeah, 15, 15 conferences.
It happens, and we did discuss it. I said last night on the program with you as a guest for that hour, I'm trying to keep the universe, positive with this. I'm not in that mood right now, Cam. I'm not going to lie to you. I'm very frustrated by this right now. It doesn't make a lot of sense to me. I'm trying to glean from what Kavanaugh said here some positive news. Let's just go through a couple of these quickly. Although the court today denies cert, a denial of cert does not mean that the court agrees with a lower court decision on that issue, or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals. I think there's something to glean from that right there, that there are other courts of appeals involved here. That's clue number one. Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certs will likely be before this court shortly. And in my view, this court should and presumably will address the AR-15 issue soon in the next term or two, which is why I'm saying I'm not doing that powwow around that campfire right now if I'm the left. But I'll tell you what, if I'm running in Virginia, I'm doing a dance right now. If I'm Maryland, I'm doing a little dance right now. Mm-hmm. There's going to be some vindication. Mainstream media is going to give this coverage the way the left frames the coverage that they want them to give. It's certainly not going to be in the frame of the discussion that we're having right now. They're not going to talk about it in this sense the way we're talking about it now. Maybe some, I don't know if they're, I don't know who is anymore, but Mixed on this, brother. And it's what do we just? I just found out from you 20 minutes ago. So
yeah, I know this is breaking news for all of us, and so the viewers here and the listeners, they're getting the unfiltered, raw takeaway. And I gotta say, Mark, I mean, one of the things that concerns me about what Kavanaugh said, he talks about some of these other cases here. So you look at this, you got the First Circuit Court of Appeals. Now, the First Circuit is, I mean, they're not going to uphold, or excuse me, they're not going to strike down Massachusetts ban on so-called assault weapons, right? Then you've got, I think it's the Second Circuit in Connecticut, NAGR versus Lamont. The appeal is pending there. You've got, as I mentioned, the New Jersey case, ANJ-RPC versus Platkin. And then you have the Seventh Circuit cases, right? You've also got Miller versus Bond out of the Ninth Circuit. That appeal is pending there. But you look at the makeup of these courts, and honestly, like I don't think there's a realistic chance that any of them, perhaps with the exception of the Third Circuit, is going to strike down any of these bans, right? Because they're just so hostile. Now, the Third Circuit is interesting because you've got, the Range case where they said, you know what? Some people who've been convicted of felonies, they should be able to have the right to keep and bear arms. They struck down Pennsylvania's ban on carrying for under 21s during a state of emergency. So there's been some reasonable decisions coming out of the Third Circuit, and maybe we'll see a good decision come out of the Third. When it comes to a semi-auto ban, but I don't understand what waiting actually gets the court. Well, unless it buys the justices time to, try to persuade some of the fence sitters.
Let's assume that the circuits that you just mentioned, and I agree with you on that, maybe possibly the Third, but there's no way these other circuits are going to strike this down. Maybe that's what's giving this court the strength based on previous rulings that says, okay, we've got 5 circuits now, including the Fourth. Don't forget, the Fourth Circuit case doesn't go away just because it wasn't granted cert. It's now precedent in the Fourth Circuit. So if you add that to the Seventh Circuit, you add that to the Third Circuit, you add that to the First Circuit, et cetera, that would provide, in theory, the Supreme Court the opportunity to go, man, they're all wrong. Now we can go in and tackle this issue that we have not just one circuit here in front of us, but now 4 that have decided this issue. And every one of them fly in the face of our statement about banning guns in common use, because Kavanaugh did mention in his opinion, but in his statement that these guns are, in fact, arguably in common use because so many Americans own them. So it would theoretically strengthen that position by the Supreme Court because they know it's going to be a monumental case no matter what. So if they can do that and have 4 circuits that have said no in clear violation of their past rulings, that in theory, that could be part of the deal. But again, we just don't know. And, I'm like you listeners, viewers, I'm like everybody else out there at this point. I'm pissed. I was not expecting this decision today. I would have put my money on it last night. In fact, I think I did put my money on it last night, that if there was news coming today, it would be better news than this. And I hate as much as anybody else watching the left do that powwow dance. I can't stand it. But again, and I almost hate to say this, I try to be level-headed about this stuff. We got to be patient. We want it all now. No, this was an opportunity for us to put this to bed. And it was an opportunity that checked every single box. So everything else we're talking about here now, as far as I'm concerned, this was a blown opportunity by this Supreme Court. No question about it. They blew this opportunity that was right before them in a case they'd already granted cert to and remanded back and vacated. So it doesn't make any sense to me. I can't wait to get the opinion of Alan Gottlieb and some other big leaders in some of these groups that have been fighting this battle. No doubt the NRA is going to put a statement out if they haven't already. You and I are right on the heels of this. This just broke 30 minutes ago. We're on Cam and Company right now. We will see statements from NSSF. We will see statements from Gottlieb at SAF and CCR-KVA. We'll see them from pro-gun organizations and state levels across the country. And then we're going to see the gloating from the left on this. So this is going to play out throughout the day. And, all we can do at this point is do what we're doing now, analyze it, and try to keep some hope alive. Let's try to keep some hope alive, ladies and gentlemen. We got to keep hope alive, right? I don't know.
I mean, you do have to keep hope alive. It is tough right now, I will say, but again, we will live to fight another day. I just hate.
I do. Let me interrupt you, Cam, because I did just get a text message right now as we're speaking from Mr. Alan Gottlieb. And I'm sure he wouldn't mind me passing this out. I won't quote it directly, but essentially what he's saying is that it's quite possible that the fifth vote was maybe not there yet, and the court is waiting for other cases to work their way up, which is kind of along the lines of what we were just talking about. I'm not convinced it's the fifth vote. I'm just again, we go to if there's any trepidation by the justices, it's no doubt coming from Roberts or from Coney Barrett. But Roberts has been with us in the three major cases of Second Amendment. Historical cases. Maybe he's wrestling with this. I don't know, but Alan brings wit and wisdom. So there's that statement right there. Again, guys, it sucks, but these things just take time. And I hate to poo-poo this off like that because I'm sick of it myself, but it is what it is.
I mean, there's no change in the court's decision, right? We're going to have to wait now and make the best of it. And, at some point, Mark, next time we have you on, I want to talk about, because we've talked about how the blue states are going to react, right? We know they're going to be emboldened. I want to leave you with this homework assignment, and maybe we'll have you back on later in the week to talk about this. What can red states do to bolster the defense of our ability to keep and carry the most common and popular rifles in the country?
That's a great question.
All right. So ponder that for a couple of days. Let's have you back on maybe Thursday. You want to do that?
I am good. Anytime you want me. Yes, that's a great question. And I already have an answer for it, but we'll hold it till Thursday. All
right. Mark Walters, host of Armed American Radio, now sponsored by the NRA, by the way. You can check him out on the Daily Defense every day. And of course, the Big Monster Cast on Sundays. Mark, thank you as always for hopping on, man. I really appreciate it. Wish the news was much better, but glad we could get your reaction today.
Any excuse to talk to you, brother. I'm good. Thanks, Cam.
Thanks, Mark. My thanks again to Mark for joining us on the program. And, again, I had not read far enough down in today's orders to see Justice Thomas's written dissent from the denial of certiorari. So I want to talk about that for just a minute. As, again, you can imagine, Justice Thomas is adamant that this ban is unconstitutional. He says, in part, the Fourth Circuit erred by requiring the challengers to prove that the Second Amendment protects their right to own AR-15s, or in the terms of our Second Amendment jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. He said a challenge need only show that the plain text of the Second Amendment covers his conduct. This burden is met if the law at issue regulates Americans' arms-bearing conduct. And once that challenger makes this initial showing, it is the government's burden to show that a historic limit on the right to bear arms nevertheless justifies its regulation. The Fourth Circuit, he says, placed the burden of producing historical evidence on the wrong party. And he said our precedents make plain the Fourth Circuit's error. In Bruin, we had, quote, little difficulty determining that, quote, the plain text of the Second Amendment encompasses, quote, carrying handguns publicly for self-defense. We consider the historical limits on the right to bear arms only to determine whether the state had met its burden of proving that its regulation was historically justified. Likewise, in Rahimi, the court found it self-evident that a law prohibiting individuals subject to domestic violence restraining orders from possessing firearms, quote, regulates arms-bearing conduct. The court again considered historical limits only after shifting the burden of proof to the government. Thomas says the Fourth Circuit based its contrary approach on an analogy to the free speech clause of the First Amendment, but that analogy, he says, only underscores its error. The court reasoned that historical evidence is necessary to prevent an overbroad understanding of the Second Amendment, just as the free speech clause excludes historically unprotected categories of speech such as libel, incitement, true threats, fighting words, or falsely shouting fire in a crowded theater. Thomas says, as we explained in Bruin, however, the government bears the burden of proving the constitutionality of speech restrictions. That burden includes showing whether the expressive conduct falls outside of the category of protected speech, by pointing to historical evidence about the reach of the First Amendment's protection. Treating the Second Amendment like any other constitutional provisions, we have similarly placed the burden on the government to show that a regulation of arms-bearing conduct falls outside the Second Amendment's protection. Under the plain text of the Second Amendment, the challenger's only burden is to show that AR-15s are bearable arms. By any measure, he says, they are. He says that the Fourth Circuit separately erred in determining that AR-15s fall within the historic exception for dangerous and unusual weapons. Thomas says our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all, quoting Heller. And he says, in line with that principle and with the tradition of prohibiting only dangerous and unusual weapons, We have never relied on our own assessment of how useful an arm is for self-defense before deeming it protected. In Heller, we found that handguns protected because that class of arms is overwhelmingly chosen by American society for the lawful purpose of self-defense. In Catano, we recognized that stun guns were protected arms solely because they were not unusual, without addressing the state's court's holding that stun guns were dangerous per se at common law. And in Bruin, he says, we again found that handguns protected solely because they are in common use today for self-defense without inquiring whether, in fact, they were useful for that purpose. In response, though, he says the Fourth Circuit's most important objection is a common use inquiry, was that it would lead to absurd consequences, such as a constitutional right to own a bazooka, a rice and pellet firing umbrella gun, or even a W-54 nuclear warhead if such weapons became sufficiently popular. This reasoning, Thomas writes, illustrates why the scope of the right to bear arms cannot turn on judicial speculation about the American people's self-defense needs. Even if some nuclear warheads are small enough for an individual to carry, no reasonable person would think to use one to defend himself. Still less could nuclear warheads ever become a common means of self-defense. To fend off the fantastical threat of Americans lobbing nuclear warheads at one another, the Fourth Circuit has allowed the very real threat of the government depriving Americans of the rifle that they most favor for protecting themselves and their families. Looking to the standards set by American society rather than by our judicial colleagues, I cannot see how AR-15s fall outside the Second Amendment's protections. And Justice Thomas says, I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade, and further percolation is of little value when lower courts in the jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. Justice Thomas says, I doubt that we would sit idly by if lower courts were to so subvert our precedents involving any other constitutional right. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. And he says the constitutional status of AR-15s is all the more urgent after this court's decision in Bondi versus Vanderstock. Recently amended regulations of the BATFE provide that a firearm under the Gun Control Act includes objects that, quote, may be readily completed, assembled, restored, or otherwise converted to a working firearm. In Vanderstock, Thomas writes, this court refused to hold that definition unlawful, reasoning that an artifact noun, that is a word for a thing created by humans, may refer to unfinished objects, and thus that weapon parts kits are as regulable as the firearms that they might eventually become. Thus, on the court's logic, he writes, it seems that the ATF could at any time declare AR-15s to be machine guns permitted by federal law because they could be converted. They could become machine guns, right? Until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is, quote, no constitutional guarantee at all. I respectfully dissent. And by the way, I would add that that's only in those states where, again, AR-15s are legal to possess. For those individuals who live in states like Maryland, where AR-15s and other commonly owned semi-automatic firearms are banned, they're already screwed. And by the way, this is not some theoretical exercise that Justice Thomas lays out about the ATF suddenly declaring AR-15s to be convertible to full auto fire, and therefore they should be treated like machine guns. The gun control lobby is already making that argument. They're making that argument against Glock semi-automatic handguns, but they've also made that argument against AR-15s in civil litigation. Now, the ATF and the DOJ, even under the Biden administration, has taken the position that no, these are two different things. But there's nothing, as Justice Thomas says, there's no limiting principle that would stop them from reversing course and changing their mind. And all of a sudden declaring that, actually, you know what, we do think that AR-15s should be treated like machine guns because with a little bit of work, they could be turned into a full automatic firearm. Justice Thomas, again, got it right. We know, again, that there are 4 justices who would overturn this ban. And I don't know what it's going to take for Justice Barrett, Justice Roberts to get off the fence, if in fact they're still sitting on the fence and haven't decided the issue. But no time like the present. But it does suggest, again, that the concerns of those justices were so deep, right? The concerns of Gorsuch, Thomas, Alito, Kavanaugh were so deep that they decided, you know what, let's kick this can down the road, because if we accept the case now, we may very well end up in the minority position. So we will have more reaction about today's decision, probably tomorrow on Bearing Arms Cam and Company, as Mark was talking about the reaction starting to come in. So I don't know who we'll be talking to, but we'll be talking with somebody from the 2A community about today's decision, which is a decision. It's not just a non-decision. The decision to not grant cert will have an impact both on those Americans living in states where these arms have been banned and in states where, again, Democrats are in a position to pass these bans either now or in the immediate future. All right, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Albuquerque, New Mexico, one of the states that I mentioned that had this go safe definition, right? Let's just treat all gas-operated semi-automatic firearms that can accept a detachable magazine as quote-unquote assault weapons and ban them. That legislation died in committee. Governor Michelle Lujan Grisham had talked about bringing lawmakers back to Santa Fe for a special session to address that bill and others, but so far we've not seen any indication that she's going to do so. But while she is interested in banning guns in the name of public safety, New Mexico has a problem with individuals who have a lengthy criminal history who are still getting slaps on the wrist. In this case, a suspect in a deadly Albuquerque police shooting had a lengthy criminal history. Not only was the suspect shot and killed by police, but the canine officer who went after this suspect died in the line of duty as well. This was last Thursday. Officers responded to a Comfort Inn in search of a 39-year-old Jorge Eduardo Dominguez. He had apparently attempted to evade arrest by jumping from a second-story window. That's when officers deployed that canine unit, and the service dog Rebel was released to pursue him. KRQE in Albuquerque says during the attempted arrest, police discovered that Dominguez was armed. Shots were fired, resulting in Dominguez being fatally shot. Rebel was also injured in the confrontation, later died from his wounds. It's unclear whether or not the shots were friendly fire, or whether Dominguez shot and killed the canine. As KRQE reports, Dominguez had a lengthy criminal history dating back almost 20 years to 2006. In 2022, 3 years ago, he was convicted of firing a weapon at another driver, but he managed to avoid prison time because he accepted a plea deal that resulted in nothing more than a suspended sentence, despite a previous record including domestic violence, battery, DUI. Most recent charge that led to police going after him last Thursday involved receiving and transferring a stolen vehicle. Again, a non-violent crime, but Dominguez had plenty of violent offenses in his past, which, again, it's a head-scratcher as to why prosecutors would offer him a deal that would result in nothing more than a suspended sentence. Again, given the laundry list of charges and convictions that Dominguez has had over the past 19 years. I'm stunned to learn that was, well, I shouldn't say I'm stunned, because it actually doesn't surprise me. But again, what is it going to take for Democrats in New Mexico, including Governor Grisham, to realize that, the problem here isn't law-abiding gun owners. The problem is a criminal justice system that routinely spits violent offenders out on the street. And part of that criminal justice system involves prosecutors who are offering these kinds of sweetheart deals. All right, on to today's armed citizen story. Now, we don't have a lot of information about this. We may get more in the hours ahead, but it comes from Charleston, West Virginia. It was early yesterday morning, 2 people injured in a shooting and robbery attempt. Let's say it started with a robbery attempt, ended up in a shootout, basically, between the assailant and his victim. According to the Charleston Police Department, it was about 1:30 Sunday morning. One man attempted to rob the other. Both shot each other. One man shot in the collarbone, the other shot in the abdomen. They were both taken to a local hospital. At last report are stable. Police say that charges are pending, I'm guessing against the would-be armed robber, not against the individual who is protecting himself. But again, we don't have a lot of information other than that, so we will look and hopefully get you more details in a future Bearing Arms Cam and Company. Finally, today, our good deed of the day, in the right place, at the right time, willing and able to do the right thing. Some good Samaritans in Port Charlotte, Florida, who helped a couple involved in a very serious crash. As WAAY reports, Alexander Machado and his wife woke up feeling deeply grateful after a terrifying crash left his work van flipped in a ditch. Accident happened around 2:30, I believe, on Sunday afternoon when Machado was driving his van. According to Machado, another vehicle, a white car, ran a stop sign, struck the back of his van, which caused his van to spin out and then overturn into a nearby ditch. He said it happened so fast, I didn't know how I was going to make it out. But help came swiftly, according to WAAY. A Good Samaritan jumping into action, climbing onto the overturned van, prying open the passenger door to reach Machado. Machado says he was reaching his hand down before I even had my seatbelt off. He was so quick, ready to pull me out. He said, I am just so thankful. Machado said he's still sore and recovering from the ordeal, but is counting his blessings, and he says that he hopes that his experience serves as a reminder for others to stay alert behind the wheel. He said, I'm lucky to be here today. People need to pay attention when they drive. It can change everything in an instant. And he is absolutely right. Again, so glad that the Good Samaritan was there. On scene, ran to Machado's aid and was able to get him out before he suffered any serious injuries. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you, as always, for being a part of the program. Looking forward to seeing you back here again tomorrow, where, again, we'll be talking more about the bitterly disappointing decision by the Supreme Court to not take up a case dealing with a ban on commonly owned firearms. And what will it take for the court to do so? Just more time? Or do we need a change of heart among one or more justices? We'll talk about it again on Tuesday's Bearing Arms Cam & Company. Be sure to check out BearingArms.com throughout the day, keeping up to date on all of the other Second Amendment news and information from around the country. And if you like what you see, would encourage you to become a VIP or VIP Platinum member, VIP Gold or VIP Platinum member. Just use the promo code FIGHT and get 60% off of your savings. You'll be supporting the independent pro-Second Amendment journalism that we're doing at Bearing Arms Cam & Company. And we greatly appreciate your support. We'll see you back here tomorrow. Until then, be well, be safe, and be free.